Beverly Hills, California, March 2021. FBI agents pull up to a strip mall. Inside, a private vault company holding over 700 safety deposit boxes. Over 4 days, they crack open every single one. They photograph the contents. They run cash past drug-sniffing dogs. They seize more than $86 million in property. Their warrant explicitly forbids all of it. But this isn't a mistake. Months before the raid, the FBI drafted internal instructions. Take everything worth more than $5,000. Not because it's connected to a crime, because $5,000 is their break-even cost for processing a forfeiture. The largest armed robbery in American history wasn't committed by criminals. It was budgeted. Somewhere in the sprawl of greater Los Angeles, tucked into a strip mall you'd walk right past, sits a building with no reason to look twice. But behind the front door, fingerprint scanners, retinal readers, reinforced steel, and more than 700 private safety deposit boxes, available 24 hours a day, 7 days a week. This is U.S. private vaults. The people who rent boxes here aren't criminals. They aren't hiding anything sinister. They're people who looked for a safe deposit box at their bank and were told none were available. People who keep cash because they don't trust themselves with easy digital access. People who store family heirlooms, retirement savings, personal documents, the kinds of things you want behind something stronger than a bedroom closet. Linda Martin is one of them. Linda and her husband Reggie live in Southern California. They have a plan. Save enough cash for a down payment on their first home. Interest rates sit near historic lows. The math works. All they need is time and discipline. So they move in with family, rent-free. They put away cash every week, every month, bill by bill. Linda won't open a savings account. She won't carry a debit card. She knows herself too well. If the money is within reach, she'll spend it. That's not a guess. That's self-knowledge earned the hard way. She finds U.S. private vaults. The security is impressive. The hours are flexible. And it's far enough across town that she can't just drive over and pull cash on a whim, but close enough for a real emergency. Over 2 years, Linda and Reggie saved just over $40,000. A down payment. A beginning. They aren't the only ones building something inside those boxes. Jenny Pearson and her husband keep silver coins and $2,000 in cash. A modest safety net, stored where it can't be frittered away. D. Mayan stores a collection of valuable coins accumulated over years, his retirement. Not in a brokerage account or an IRA, but in metal he can hold in his hands. Every customer at U.S. Private Vaults follows the same instruction from the company. Tape an emergency contact form to the inside lid of your box. Name, phone number, next of kin. If anything ever happens, someone can reach you fast. 700 people do exactly that. None of them know what's coming. U.S. Private Vaults, the business itself, not the customers, is under FBI investigation. Federal agents suspect the company of fraud and financial crimes. The probe has nothing to do with the people renting boxes, nothing to do with Linda's down payment, nothing to do with Jenny's coins or D. Mayan's retirement. But the FBI isn't just planning to shut down a business. They want what's inside those boxes, and they already have a plan to take it. Before we get into what the FBI actually wrote in those internal instructions, what they plan to do with every box before they ever touched one, subscribe. Because what comes next is the part they promised a federal judge would never happen. To raid U.S. private vaults, the FBI needs a warrant, and the warrant creates a problem. The business operates out of a single building. 700 safety deposit boxes sit physically inside that building. If agents seize the premises, they will inevitably come into contact with the private property of 700 people. People who are not suspects, not under investigation, not accused of anything. The FBI knows this, and it knows no federal judge will sign a warrant that authorizes the mass search and seizure of innocent people's belongings without probable cause. So the Bureau makes a promise. In its warrant application, the FBI tells the magistrate judge it will only open a box if necessary to identify its owner. If a box must be opened, agents will create a careful inventory of the contents to protect against claims of lost or stolen property. Nothing more. No criminal search, no seizure of anyone's personal belongings. The target is the business, not the boxes. There's just one detail the FBI leaves out. Before filing the warrant application, before making any of those promises to the court, the Bureau has already drafted a separate set of instructions, supplemental procedures, written internally and distributed to every agent assigned to the raid. Those instructions say something very different from the warrant. Any box containing more than $5,000 in cash is to be forfeited. Not because the owner is suspected of wrongdoing. Not because the money has been linked to any criminal activity. At this point, the FBI doesn't know who owns most of the boxes. It has no probable cause against a single one of the 700 customers. $5,000 is simply the number at which forfeiture becomes profitable for the Bureau. Below that line, the paperwork and processing cost more than the take. Above it, the agency nets a gain. This isn't inference or speculation. The FBI confirmed it under oath during court discovery. $5,000 is the minimum threshold that ensures the Bureau makes money on the seizure. The same supplemental instructions arrange for drug-sniffing dogs to be present on site during the raid, staged and ready to screen every bill pulled from every box. Nothing about drug-sniffing dogs helps identify a box owner. Nothing about forfeiture thresholds appears anywhere in the warrant. The magistrate who signs the order has no idea these instructions exist. Had he known, the warrant almost certainly would never have been issued. March 2021. The FBI holds a warrant built on promises it has already decided to break, and a set of secret instructions designed to turn a business takedown into the largest mass seizure of private property in American history. The agents arrive on a Monday. The operation takes 4 days. FBI agents, personnel from 2 additional federal agencies, officers from multiple local law enforcement departments. They move through U.S. private vaults box by box, systematically, 700 and counting. The emergency contact forms are right there, taped to the inside lid of every box. Exactly where customers were told to put them. Name, phone number. Everything the FBI would need to identify an owner without opening a single container. The agents blow right past them. Every one. Every box is cracked open, not just the ones without visible contact information. Every single box in the building. And they don't stop once they've identified the owner. They keep going. Through every item, every document, every personal belonging stored inside. Cryptocurrency passwords, immigration records, family photographs, legal documents never meant for anyone's eyes. In one box, the cremated remains of someone's loved one, held up and cataloged like evidence in a case that doesn't exist. Everything is filmed. Everything is photographed. Video cameras run while agents sort through the intimate details of 700 private lives. When they find cash, and they find a lot of cash, they run it past the drug-sniffing dogs stationed on site. Every stack, every bundle, every loose bill. How a dog's reaction to currency helps identify the owner of a safety deposit box is a question the FBI has never answered. And the inventory, the one the FBI promised the court it would carefully maintain to protect innocent owners from property loss, is a fiction. Cash is logged as 2 words: U.S. currency. No dollar amount, no count. Jewelry becomes assorted jewelry. Coins become miscellaneous coins. Some boxes are summarized in their entirety as assorted general items. The whole of someone's retirement savings, reduced to a phrase that could mean anything and proves nothing. These are the records the FBI told a federal judge would safeguard owners against claims of lost or stolen property. By the end of 4 days, agents have seized more than $80 million in cash alone. With jewelry, coins, and other valuables, the total exceeds $86 million, taken from over 700 boxes, belonging to people the FBI has never investigated, never charged, and has no evidence against. Everything the warrant forbids. Criminal searches, drug screenings, mass forfeiture happens systematically across every box over 4 consecutive days. Everything the warrant requires, minimal intrusion, careful documentation, protection of innocent owners, never happens at all. This isn't a raid that spirals out of control. This isn't field agents exceeding their authority in the heat of a tense operation. This is the supplemental instructions, executed to the letter. When the story breaks, the FBI controls the narrative. A corrupt business taken down, a blow against organized crime, a facility that harbored drug money and sheltered criminals, dismantled by federal agents doing exactly what federal agents are supposed to do. The media runs with it. The footage looks like every law enforcement victory reel: tactical gear, evidence bags, yellow tape. The implication is clear. If your property was inside that building, you probably had a reason to hide it. For 700 box holders, this is a nightmare layered on top of a nightmare. Most are innocent. All of them know it. But going public means attaching your name and face to a building the FBI just called a front for criminal activity. The first lawsuits are filed under fake names: John Doe, Jane Doe. People aren't looking for a fight. They just want their things back, quietly, quickly, before anyone associates them with the raid. Linda Martin doesn't file anything. She doesn't even know yet. She finds out from her television. She sees the building on the screen. She sees agents carrying boxes out the front door. She turns to her husband Reggie and screams, "That's us! That's our place!" They drive across town to confirm. The money is gone. Every dollar. 2 years of living rent-free with family. 2 years of refusing to carry a debit card. $40,000. Gone. Then the letter arrives. A notice from the FBI, 2¼ pages. It informs Linda that her property has been seized in connection with a possible federal crime. It does not say which crime. It does not explain what connects her money to any illegal activity. It does not name a suspect, a statute, or a single supporting fact. It gives her 2 options: file a claim in federal court, hire a lawyer, face a U.S. attorney, navigate the full machinery of federal litigation just to prove that her savings belong to her and she hasn't done anything wrong. Or submit a petition for remission directly to the FBI. No court, no judge. The agency that took her money decides whether to return it. The second option is designed to look easier. It is designed to be worse. Filing a petition means conceding that the FBI has the right to keep the property. It means asking for a favor, not asserting a right. Everything submitted goes under penalty of perjury. Everything provided can be used to justify further investigation, not just of the property, but of the person, their family, their finances. And the process that follows has no guardrails. No timeline for a decision, no judicial oversight, no standard of proof. The FBI decides what to consider, when to respond, and whether to respond at all. Linda tries to resolve it the simple way. She contacts the Bureau directly, explains the situation. There must be a mistake. She's told they'll look into it. They never do. Months pass, then more months. Her money sits in federal custody while Linda and Reggie watch their window for a first home close. And it's not just delays. Some property doesn't sit in custody, it vanishes. Ginny Pearson fights the FBI's attempt to forfeit her silver coins and wins. Then she asks about the $2,000 in cash that was in the same box. The FBI says there was no cash. Never was. The inventory. Those two words, U.S. currency, scrawled on a form, shows nothing specific enough to prove otherwise. D. Mayan's retirement coins disappear entirely.
No judge.
Thousands of dollars in collectibles, gone from FBI custody without a trace. The inventory that was supposed to protect him is the reason no one can prove what he lost. The FBI told a federal judge its procedures would safeguard property owners. Those procedures are now the instrument of their loss. Most people facing all of this, the fear, the bureaucracy, the vanished property, the weight of the federal government, stay quiet. But not everyone. Paul and Jennifer Sneeko are the ones who break the dam. They're box holders like the rest, innocent like the rest. But they refuse to hide behind a pseudonym. They go public with their names and their faces, not through a carefully worded legal filing, but as themselves, standing in the open, saying what no one else is willing to say. The FBI is wrong, and someone has to say it out loud. Their decision opens a door. Other clients step through it. The Institute for Justice, a nonprofit civil liberties law firm, files a class action on behalf of every box holder whose property was wrongfully searched and seized at U.S. private vaults. Discovery begins. And what the documents reveal is worse than the raid itself. The internal records confirm it. Before applying for the warrant, before the magistrate ever saw a word of the FBI's promises, the Bureau had already decided that any cash over $5,000 would be permanently forfeited. The decision was made without knowing who owned any of the boxes, without suspecting anyone of anything, without a shred of individualized probable cause. It was a revenue calculation dressed as law enforcement. The case reaches the Ninth Circuit Court of Appeals. 3 judges, 1 unanimous conclusion. The FBI violated the Fourth Amendment. The search cannot be justified under the inventory exception because the FBI never created a legitimate inventory. The drug-sniffing dogs, the blanket photography, the supplemental forfeiture instructions, none of it matches the FBI's own standard inventory procedures. These weren't tools of documentation. They were instruments of a criminal search, disguised as something the warrant permitted. A majority of the panel goes further. The FBI didn't just exceed its warrant. It actively concealed its forfeiture plans from the magistrate. It obtained judicial approval through deception, then executed the precise search the warrant explicitly prohibited. And then the court reaches for a comparison that cuts deeper than any legal ruling. The judges compare the FBI's conduct to the writs of assistance, the general search warrants used by British colonial authorities in the 18th century. The writs that allowed agents of the Crown to enter any home, open any container, and seize any property for any reason with no judicial oversight and no recourse for the owner. The writs that so enraged the American colonists that they became one of the sparks that ignited a revolution. The writs that the Fourth Amendment was written, specifically, deliberately, and permanently, to ensure would never be used in America again. 250 years later, the FBI replicated them at a strip mall in Beverly Hills. After oral argument, but before the written opinion comes down, the government folds. It concedes everything. It agrees the court should enter the full relief the plaintiffs are seeking. The FBI does not wait for the ruling. It surrenders. Linda and Reggie get their $40,000 back. It takes 2 years and 1 month. The FBI holds the money for 24 months. It returns the money 4 weeks after the lawsuit is filed. Then it argues the case should be dismissed, that because it voluntarily gave the money back, there's nothing left to fight about. The court doesn't buy it. Jenny Pearson is still suing for cash the FBI says never existed. Dee Mayan is still suing for coins that disappeared from federal custody. Both cases remain open. But here's what hangs over all of it. Between 2017 and 2021, the federal administrative forfeiture system, the one with no judges, no juries, no standards, and no review, moved more than $1.1 billion into government accounts. Not from convicted criminals, from property. Property belonging to people who, in many cases, were never charged with a single offense. The FBI's raid on U.S. private vaults wasn't an aberration. It was the system operating at full capacity. The $5,000 threshold wasn't a legal standard. It was a business decision. And business, for the federal forfeiture apparatus, has been very good. The Fourth Amendment was written because the founders knew what unchecked search power looked like. They had lived under it. They had watched Crown agents enter homes without cause, seize goods without process, and answer to no one. They wrote a constitutional wall to make sure it never happened again. In March 2021, the FBI walked through it. 700 boxes, $86 million. 0 criminal charges. The court called it unconstitutional. The system is still running. 700 boxes, $86 million. 0 charges. If this story changed how you think about what sits in your own safety deposit box, or what actually stops the government from opening it, share this video. And if you want to see what happens when ordinary people decide to fight back, subscribe. This story isn't over.